Please rise. The justices of the Appellate Division of the Supreme Court First Department, ADP, all persons having business with the Appellate Division, draw near, give your attendance, and shall be heard. Please be seated. Good afternoon and welcome to the Appellate Division, First Department. Most of you know the rules here. I will be calling the calendar. We'll ask you for what argument time you would like. Please ask only for the time you actually need, not the time that you want, so that I don't have to do it for you. Understand, we have read your briefs, the record, we're familiar with your cases. The time clock is for you, not for us. So if we have more questions, we will continue beyond the light. That being said, let us begin. People versus Bertrand Delisme. 6 and 2 and 6. Philippides versus Multi-Pack Corporation.
Good afternoon, Your Honor. Request 6 and 2.
Respondent request 6 and 2, Your Honor.
Okay, 5 and 1 and 5. People versus Daniel Ventry. 4 and 1 and 4. Cadigan versus Liberty Helicopters. 5, 2, 5, and 3. People versus Bernabe Lopez.
Request 5 and 2, please.
5 and 2 and 5. Corletto versus Euclid Hall Housing. Oh, all right, would you like to submit? Okay. Okay. Thank you both. JG Jewelry versus TJC Jewelry. Okay. Is the appellant here? You're the appellant, okay. So this one is 5 and 1 and 5. Like I said, the light is for you, not for us, okay? So if we have more questions, we'll continue. People versus Morgan McGee. Okay, 4 and 1 and 4. Rose Group Park versus Third Church Christ.
Requests 8 and 5, Your Honor.
Okay, 6 and 2 and 5. Max Marcus Katz versus Sterling National Bank. Is there a cross appeal? Yes, sir. Okay, 5 and 1 and 5 and 1. Pala Assets Holding versus Rolta is a submit. Perez versus 76th and Broadway is a submit. Wilner versus Norcell Realties is a submit. First case on the calendar, People versus Delisme.
May it please the Court, Rosemary Herbert, Office of the Appellate Defender, on behalf of Mr. Delisme. Bertrand Delisme's conviction must be reversed where the trial court erroneously instructed the jury that Mr. Delisme had a duty to retreat and did so in a way that effectively negated his justification defense. Now, there is no dispute about where this incident took place. It happened in a bathroom that was shared by Mr. Delisme and the complaining witness, Mr. Davis. It is also undisputed that these are the only two people who had access to this space.
Well, counsel, let me just ask this. Did the trial judge actually instruct the jury that the defendant had a duty to retreat, or did she instruct the jury that it was up to them to make that determination?
By the terms of the court's instruction, the court left this up to the jury, but it also did so in a way that effectively directed them to find that this was not part of Mr. Delisme's dwelling, because it omitted critical language from the standard instruction and spoke only in terms of Mr. Delisme's ability to exercise exclusive.
So you're talking about that portion of the CJI charge, the CJI charge in the parentheticals, which she did not read to the jury. Now,
Correct, Your Honor.
So in terms of that, was there an objection, a specific objection to that omission by the defense?
Your Honor, there was no specific objection to that omission. Defense counsel did object to the giving of any instruction on the duty to retreat, but counsel did not specifically object to the language that was used by the court.
So therefore, is that something that is unpreserved and therefore something that we cannot consider?
Well, of course, the court can consider it in the interest of justice, and I think the court should do so here, where this goes to the heart of Mr. Delisme's justification defense. The concept of the dwelling as an exception to the duty to retreat is well established, and the Court of Appeals has, in cases that are discussed in the briefs, taken pains to define that term. And specifically, the court has recognized that there are and this is a quote, a myriad of different living situations that basically this could apply to. And here, Mr. Delisme, like many New Yorkers, lived in, I think, what is a non-traditional living situation. He had a private space, but then a shared bathroom, and he had the ability to exclude everyone other than his neighbor from that shared space.
So what about the People v. Hernandez, where the Court of Appeals talks about the exclusivity of the dominion and control over the particular area?
Correct, Your Honor, but again, it is from the Court of Appeals decision in Hernandez that parenthetical language that was omitted by the court derives.
Are you referring to the language that says others sharing in that dwelling?
Yes, absolutely, Your Honor. The language that was not included in the court's instruction that comes from Hernandez that is included in the pattern instructions talks about whether this is part of the dwelling depends on the extent to which the defendant, and this is the parenthetical language that was omitted, and persons actually sharing living quarters with the defendant exercises exclusive possession and control over the area in question. With that portion omitted, again, Mr. Delisme did not have exclusive control because he did not have the authority to exclude his neighbor from that space. But if you include that language, he did have that authority, and this area should have been properly considered part of his dwelling.
So what about the language in the charge where she says the determination of whether a particular location is a part of the defendant's dwelling depends on the extent to which the defendant exercises exclusive possession and control over the area in question? Would that not be sufficient?
No, Your Honor, because again, here there is, because of the nature of this living situation, Mr. Delisme did not have exclusive control. He had exclusive control along with the person, or persons, in this case it was one person, sharing living quarters. So that omission was critical here.
So turning to then the question of deadly physical force, if the defendant, even assuming the defendant did in fact have a duty to retreat based upon his, the fact that that was a part of his dwelling, do we not also have to look to whether or not he reasonably used deadly physical force to compel deadly physical force?
Your Honor, first of all, the duty to retreat arises obviously in the context of the use in response to the threat and use of deadly force. And someone who is in their dwelling has no duty to retreat before availing themselves of deadly force in order to respond to the use or threatened use of deadly force. Here, the court believed, and again, that there was a reasonable view of the evidence that required submission of this charge to the jury, and I think that that is appropriate. It was a classic credibility contest between the version supplied by the complaining witness, which had significant credibility problems, and the version supplied by
So
the
because the defendant was in his dwelling and therefore had no duty to retreat, he could use deadly physical force to repel any type of physical force?
He could, to repel the threat and use of deadly physical force.
Exactly. And so
Absolutely.
where in the record does it support that the complainant was using deadly physical force, or that the defendant was using deadly physical force because he reasonably believed that the complainant was using deadly physical force?
You may answer.
Your Honor, that can be found in Mr. Delisme's testimony, which I think fairly read supports the conclusion that he feared a deadly attack from his neighbor, with whom he had a history of exchanging angry and threatening sort of verbal communications, including specifically that morning. And for these reasons and the reasons set forth in our brief, we would ask that the conviction be reversed.
Thank you.
Good afternoon, Your Honor. Sylvia Wertheimer for the people. The court properly declined to rule that as a matter of law, this shared bathroom constituted a dwelling for these purposes. As my
How? Under our precedent, I don't understand how the court reached this decision.
well, the court, because the defendant did not have, he did not have the right to exclude his next door neighbor.
But that's not the issue, right? The issue is whether this bathroom constituted a part of his dwelling, and therefore whether he had a duty to retreat. That's the issue.
Okay, but when you talk about the dwelling in terms of a duty to retreat, we're not talking in the abstract, like, does the defendant have a right to a bathroom? I think in Hernandez, the court says you have to look at what constitutes a dwelling.
In Hernandez, this happens in a hallway and the lobby of the building. This is not an apartment that's being shared by two people.
This is, I'm sorry.
Totally, the facts do not at all square with this case.
So, counsel, let me ask you, do these two people share a room?
No, these
They have two separate apartments, right?
What you
They have
have
their
here
own
is
apartment.
two entirely separate apartments.
Counsel,
These
isn't this similar to a situation where, say, two students share an apartment? Each of them has a bedroom, they share the kitchen, they share the bathroom. Certainly, those two students would each view the bathroom as part of their dwelling space. Isn't this identical? Isn't that this, as a matter of law, identical to
Well,
that situation?
I don't think that if people have entirely separate, these are entirely separate rooms. These people had no other interaction with each other.
I understand, but
they could never be in the bathroom
But in a roommate situation as well, each of the people would occupy their bedroom exclusively, and they would use the bathroom alternately, not at the same time. How is that really any different?
Okay, well, I think I have two things I'd like to say. First, looking at it from the terms of the policy behind the dwelling exception. The policy is...
Wait, before you get to the policy, I want you to answer my colleague's question. We have two rooms that are adjoined by basically a Jack and Jill bathroom, okay? Each person in this SRO was entitled to use that bathroom.
Yes, but that didn't make the bathroom...
And no one else from the SRO could access this bathroom other than going through these two rooms. So there's no question that this bathroom was part of the dwelling of both of these two rooms.
Well, if that's true, even if that were true, we would say that any error would be harmless because there was no reasonable view of the evidence here that the defendant reasonably believed that he needed to defend himself against the use of deadly...
The problem with that argument is that in light of the charge that was given, we have no idea whether the jury reached a verdict on the issue of he didn't have a right to use deadly physical force in this situation, or he was supposed to retreat. I don't know what was the reasoning of the jury because of this jury instruction.
Well, I think you know that the instruction first requires that the defendant before you even get to the question of a duty to retreat, the jury would have had to have found that the defendant reasonably believed that he was being threatened with imminent use of deadly physical force. There is nothing in the record, not one thing, that suggests he was being threatened with deadly physical force. He said that that the Davis hit him with an object. He didn't try to hit him with an object. He didn't describe the object. He didn't say one thing about the object. No object was found. There's nothing to suggest it would have been, there's no way that same thing as in Jones, that evidence just did not support.
Except that you have a judge who gives the justification charge.
Well,
So
but
obviously, the judge felt that there was enough on the record
Yes, but
for it to go to the jury.
the justification was also a defense for the use of ordinary physical force, where the duty to retreat did not
But you're
apply.
assuming, counsel, you're assuming that the jury took it one at a time, that they looked at one, whether the defendant reasonably used deadly physical force in order to repel what he believed to be deadly physical force, and then either did not look to the issue of the duty to retreat or ignored it or what have you. So, I mean, but we don't know that is what occurred,
Well, that's
right?
that's the way the instructions were laid out. The instructions were laid out that you had the right to use a deadly physical force, first, if you reasonably believed that it was necessary to defend yourself against the use of
Did the verdict sheet break this
No,
down into...
the verdict-
Counsel, it would help if you let me finish my statements before you jump in.
I apologize.
Thank you. The verdict sheet did not have a specific set of questions so that we could discern, right? Because if that had happened, if there had been a question on the verdict sheet that said, was this a dwelling? Then we wouldn't be here. We'd know the answer. We'd know what the jury found, on what basis. We don't know. We're guessing.
But I think that's often true, but I think I direct Your Honor's attention again to the Jones case, where I think it was the same situation, and where the Court of Appeals said that even though they found that there was error in the instruction, that it was harmless and didn't warrant reversal because there was no evidence that could have led the jury to even reach the issue of the duty to retreat, because there was no evidence in which they could have found a threat of the use of deadly physical force. And that's the same here. There's absolutely not one thing to suggest that a defendant, even under defendant's own testimony, he doesn't say anything about something that would be deadly physical force.
Okay, thank you.
Thank you.
Counsel, you have 2 minutes.
Very briefly, Your Honors, I would note that in the charge conference in the case below, the prosecution did not object to the giving of a justification charge. In fact, the sole focus of the prosecutor's arguments regarding the charge was that the use of ordinary physical force should not be given. Here, obviously, the judge believed that there was a reasonable view of the evidence, chose to submit to the jury, and as Your Honor has noted, we don't know on what basis the jury reached its decision. And here, given the nature of the court's instruction, the danger is simply too great that they relied on the inaccurate charge, which would have led them to believe that Mr. Delisme had a duty to retreat. Unless there are any further questions, we rely on our brief and ask that the conviction be reversed.
Thank you so much.
Thank you.
Okay. Philippidis versus Multi-Pack Corporation.
Good afternoon, Your Honors. I may it please the court. My name is Kristen Gianaris for the defendant appellant, Milford Management. Milford's submission of the management agreement, the affidavit of Ms. Gold, and the plaintiff's employment file was sufficient to establish a special employment
So
relationship.
you mentioned the affidavit of Ms. Gould. Was she employed by Milford at the time of this incident?
She was not, Your Honor, and we acknowledge that fact. I know that this is something that the respondents leverage in their briefs.
Well, I wouldn't use the term leveraging, but I mean, I think it's a viable argument. Would you not agree?
Well,
So this is a motion for summary judgment, right?
correct.
So why are there not issues of fact as to whether he was a special employee or not? We have, I believe his pay stub says Liberty, right?
It does.
So Liberty Condo paid him, but then Milford had the ability to hire, fire, and I think there was terminate, and I think there was also training, right?
It was supervised.
Supervise. So again, there are issues as to Liberty Condo's supervision and whether he was an employee of Liberty Condo, whether he was an employee of Milford. Issues of fact that I see them, so why would summary judgment be appropriate?
Summary judgment's appropriate here because the documentary evidence submitted by Milford established that basically Milford undertook all facets of a traditional employer-employee relationship with the plaintiff here.
Wasn't the contract that was between Milford and Liberty, didn't it expire before this accident?
Your Honor, although there is a one...
And there was a second contract that, I guess it was a renewal, that was after this accident. So the focus is let's assume a contract would govern the scope of responsibilities of Milford to act as a special employer. We don't have direct evidence right now, and as my learned colleague pointed out, there are issues of fact based on other documentary evidence. For example, the plaintiff put into the record a number of copies from the Workers' Comp Board giving him benefits, of which employer is listed as Liberty Condo. Now, I understand the difference between general and special.
Yeah.
I get that. But the question is on this record, it sounds like it's an issue of fact, and then you could really sort it out later on in terms of describing.
Just to address the first portion of your question about the management agreement being expired,
Sure.
Ms. Gould's affidavit specifically set forth that the management agreement appended to her affidavit was in effect at the time of the August 2017 accident.
Well,
What is
counsel,
the basis for her
yeah.
knowledge? She didn't start working for them until 2020.
That's true, Your
She
Honors.
hasn't set forth what the basis is for her knowledge, so how can we rely on that on this record? You may be able to establish it eventually, but on this record, how can we rely on her account of that?
Well, given what her background is and her role is at this company, she's the managing director.
That doesn't matter. She has to either have personal knowledge or give us information on the record as to how she obtained her knowledge. And she doesn't do that. She just says it was in effect.
I understand that, Your Honor. She does state in her affidavit that her duties require her to maintain all paperwork on behalf of Liberty Court for this property. This property is in her portfolio, and also all these records are maintained in the regular course of Milford's
But
business.
she did not maintain the records at the time of the incident because she was not employed by Milford in any capacity. Maybe you could make that argument if she was employed by Milford in some other capacity, maybe, so therefore she knew what was going on, but she was not employed by them at all.
Even if we step away from what Ms. Gould's affidavit states, the management agreement itself and the contents of the employment record, I think, are more than sufficient to show a
The
special
management agreement says that this is Milford's employee and not yours. That's what the management agreement
Liberty.
says.
That's correct, Your
At
Honor.
Liberty, yeah.
And in that regard, I would point the court to its earlier decision in the Gardner case cited in our brief. The same exact facts were at issue. This court found a special employment relationship, notwithstanding the identical provision in the management agreement, setting forth that the employees would be the employees of the building owner and not the managing agent. What's important here is to look at whether or not Milford supervised and controlled this employee's work.
What do we do about the workers' compensation records wherein they made a determination that the plaintiff was an employee of Liberty?
I would say, Your Honor, that doesn't affect or bar a special employment finding here, because the whole point of this analysis recognizes that an employee can have two employers, even if he's paid by one employer and or is generally employed by one employer, which would be Liberty Court here. We acknowledge that. But the factual circumstances as to what happened in that employment, such as here, he was actually supervised by
All right,
Gus.
you said that before, you'll have time on rebuttal.
Thank you,
Okay?
Your Honors.
Thank you. You may proceed.
Good afternoon, Your Honors. Larry Green, O'Toole Scrivo for respondent defendant. May it please the court. Your Honors have already pointed out most of the strongest points in our brief, and I won't rehash those. I would just point out we were compelled to oppose our co-defendant's motion for summary judgment because it was woefully premature. It was submitted before there were any depositions, any meaningful discovery exchange. There was actually discovery that was withheld, and we had to go back and say there's things that are missing. So at that point, it is just premature. As Your Honors pointed out, the contract itself indicates that he's not their employee. He is Liberty Court's employee.
And I pointed that out, but you know as well as I do that there is case law that says even if there's a management agreement with this language, if the other indicia show that that a person is a special employee, that entity will receive the benefits of that designation, right?
Absolutely, Your Honor. A person can have a special employee relationship and a general employee relationship. That's a highly fact-specific inquiry that is generally left for the trier of fact, is not usually disposed of on a motion for summary judgment before there are any depositions. Not to mention, as Your Honors all noted, Ms. Gold was hired 3 years after this accident. The records she purports to rely on, many of them say Milstein Properties, an unnamed non-party.
Right.
So that even the statement or assertion that these are Milford's records is questionable. And for all these reasons, it's beyond clear that this is far too premature, and there's no possible way at this stage that Milford can meet its prima facie burden for summary judgment.
So, counsel, you represent Multipack, right? Which
Yes,
was
Your Honor.
the entity that installed the compactor. Is that correct?
Yes, Your Honor. We don't know what the evidence will show, but we certainly could not allow our co-defendant to leave the case at this early juncture.
Right, because then you'd be on the hook. So I just wanted to be clear, you're doing this not, for any altruistic reasons, but just, you don't want to be left on the hook, right?
We always like to share.
Right,
and,
misery loves company, yeah, I got it.
Yes, Your Honor. And so with that, unless Your Honors have any further questions from me, I'll rest in my briefs as to the rest of the arguments.
Thank you. You have a minute.
Just brief.
That's an interesting argument or observation, is that some of the records do state Milstein. Is there any connection between the two in the record by any entity, by anyone?
It's not borne out by the record. I think these clearly are related entities. I can't answer that question with more specificity, but I will point out that.
So doesn't that create even more issues of fact?
No, Your Honor, because the records that we rely on, and in fact the majority of the records are Milford records. It's just a few, like the initial background reports or something like that, that say the Milstein Properties logo on top.
But part of what troubles me is that you've still never addressed the question that was asked by several of my colleagues about the fact that there was no management agreement in effect at the time of the incident.
Oh, I'm sorry. I'll answer that. Ms. Gold's affidavit set forth that, and also there is a workers' compensation policy in the record listing Milford as an insured, which is active for the period in the year of the accident from July 2017 to July 2018. And I think that further substantiates this statement by Ms. Gold that this was active at the time of the accident.
We've already, I think, you have not satisfactorily answered that Ms. Gould has any knowledge that we can rely on about what happened before she got there in 2020. So putting aside Ms. Gould, it seems to me that what you just raised simply creates more questions of fact that should preclude summary judgment here. So I don't see your entitlement.
Again, Your Honor, I would just point back to the actual employment file here. It demonstrates that plaintiff was supervised by Milford's employee, Gus Uranitsas. This is the individual who created the accident
Right, and that was another
report.
thing, because apparently he was employed by Milstein, and there was nothing in the record as to how he was actually employed by Milford, right?
There's actually evidence that he was employed by Milford. If you look at page 116 of the record, there's an email, and Mr. Uranitsas has an @milfordmanagement.com email.
But I thought Gould didn't state as to how Gus was a Milford employee, only that he was supervised by an unnamed Milford employee.
There are indications in the record that bear the Milford heading. where Mr. Uranitsis's name appears as the supervisor for plaintiff.
Okay, thank you. We have your record and the briefs. Thank you.
Thank you, Your Honors.
People v. Daniel Ventry.
Good afternoon, Your Honors. May it please the court. My name is Cara Labini for Appellant Daniel Ventry. Mr. Ventry's defense in this criminal mischief case was that he was too drunk to form an intent when he broke 2 of Mount Sinai's computers. And indeed, the incident occurred just 3 hours after he was admitted to the emergency room with acute alcohol intoxication. In relevant part, Mr. Ventry's medical records contained 3 statements describing how much he regularly drank. 1, 30 cans of beer per week. 2, a liter of vodka per day. And 3, 360 ounces of
But
alcohol.
what's relevant is what he drank that day, right? It doesn't really matter what he drinks on a normal basis. The only thing that is relevant for an intoxication defense is what you drank that day.
Well, the statements, I drink a glass of wine every day, means that on each day I drink a glass of wine.
But today I
So
decided
what?
not to have any wine. I mean, what my colleague states is obvious to me. The fact that you drink 30 beers per week and 1 liter of vodka a day, again, what did you drink on that particular day? How do we know that that was not the one day that he decided, I'm not drinking today?
But I think that...
And indeed, your client testified on this day, I didn't drink vodka, I had scotch, I believe it was. So I am at a loss for why there is an argument that it is error for the court to not have allowed this general statement about what he usually drinks. So what he usually drinks? The only relevant thing is what he drank that day.
And he was allowed to testify, was he not, at trial as to what he drank that particular day? He wasn't
Yes.
precluded. That testimony wasn't precluded.
Putting his testimony aside, the statement, I drink a glass of wine every day, makes it more likely that I had a glass of wine on.
But that's not the standard of proof in a criminal case, what is more likely than not, right?
Well, it tends to show, which is irrelevant.
Counsel, the standard of proof on a criminal case is proof beyond a reasonable doubt, not what is more likely than not.
Of course, but on a
So
relevance...
what he was more likely than not to drink on any given day is irrelevant, totally irrelevant, totally.
I think...
So speak to me about what evidence was either precluded that should have been allowed, other than irrelevant general statements about what he usually drinks.
Well, so your position is that the third statement as well was inadmissible?
We don't have a position. Excuse me.
You're the one with a position.
Yeah, absolutely. I'm just, under that reasoning, the court was incorrect in admitting the third statement as well. I mean, if we talk about Mr. Ventry's testimony...
I'm sorry, I didn't understand that. Repeat that, please.
Just that on the grounds that, of your argument, the court was...
Counsel, let me stop you. I have no argument.
Sure.
You have an argument. You're trying to convince us of a position. I am challenging your argument. That's our job, okay? So don't perceive my questions as my rock-solid position. I am testing your position, okay? All right.
Of course, Your Honor, I apologize.
No need to apologize. Let's just set the ground rule right.
So what was the third statement that you were referring to?
That he drank 360 ounces of alcohol per week, which was admitted.
It was redacted, right?
No, it was admitted. There were 3 statements: 30 cans of beer per week, 1 liter of vodka per day, 360 ounces of alcohol per week. The third statement was admitted. The first 2 were not.
And so your argument is what? In terms
That
of
they
the
all
fact
should
that
have been admitted.
That they were all admissible, whether they were, whether there could have been an argument as to cumulativeness or weight is a different question than admissibility.
Okay, got
Thank
it.
you.
You'll have time on rebuttal.
Good afternoon, Your Honors, and may it please the Court. Emily Galt for the people.
So why admit that third statement that's in the social history section? Why admit that and not admit everything else?
I think the judge believed that the 360 ounces of alcohol per week covered the other two statements, which it was in fact a miscalculation because, as defense counsel pointed out in their brief, 30 cans of beer per week is equivalent to 360 ounces. So the 1 liter did not account for that. But so the judge's reasoning was that that's in there, that's enough. But either way, the jury was well aware of defendant's drinking habits because of that statement. And also, as Your Honors pointed out, defendant testified at trial, and there was absolutely no evidence that he drank a liter of vodka that day. He testified at trial that he woke up around 8 a.m. and 10 a.m. He got a liter of scotch. He was halfway through the scotch, and he bought a case of beers. And at 2 a.m., when he woke up in the subway station, so about 18, 20 hours later, he still had half of the case of beers left. If he drank a liter of vodka, as they are now saying on appeal, he could have testified to that at trial, but he did not say that, and what defendant drank each day of the week or every other day was not relevant to the day in question. And if Your Honors have no questions at this time, we ask that you affirm. Thank you.
Counsel? We talk so much, I'm going to give you a little extra time.
Oh, thank you. I don't think I need too much.
Okay.
Mr. Ventry was admitted to the emergency room drunk. That was why he was admitted to the emergency room. And he was discharged only 3 hours later with the conclusion that he was apparently fine to go home. The jury did not have, our position is that the jury did not have all the admissible evidence as to how much Mr. Ventry regularly drank. It's certainly...
But you still have, but the question, that begs the question of why how much he regularly drank is relevant to how he was, what his condition was that day, because we do know what he said he actually drank on that day. So why did they need the other?
Well, it's possible that because a testimony that relayed he drank a liter of vodka, a liter of scotch, and 12 beers in one day, it's possible, I mean, that type of testimony, if it was true, it's possible that counsel encouraged him not to testify as much because drinking that much in one day would have seemed incredible to some jury members. So it's possible that he omitted that and wasn't pressed, even though if it was true, because it would have made it seem like an exaggeration. But with the support...
I don't recall, was there an actual diagnosis that he was intoxicated?
He was admitted for acute ETO, ETOH, alcohol intoxication.
But I thought that there was also testimony by the doctors that there was an issue as to whether he actually was intoxicated. Because no tests were run. They didn't do an alcohol...
He didn't allow it.
Yeah, nothing was done.
Well, he didn't allow it after the police were already called, after the computers were already damaged. We don't know...
But it was suspected that he was intoxicated. There was no real evidence that he was intoxicated other than unsteady. They said he was unsteady on his feet a little bit.
I mean...
I thought there even was statements that he didn't even smell of alcohol.
He was admitted for acute alcohol intoxication. That's what his medical records say.
But they also stated that no one really saw any or observed any indication that he was intoxicated.
This was a man who was picked up in the subway, covered in his own vomit.
I understand all of that, but all I'm saying is that you talk about that he was intoxicated, but I thought that was the whole point. There was nothing in the record showing that he was intoxicated. No smell of alcohol, no tests were run, no bloodshot eyes, nothing. He did throw up, yes, but other than that, I thought that the doctors were unclear that he was actually intoxicated.
The ambulance was also delayed in triage because of how much vomit Mr. Ventry spewed. And
Yeah, but that,
Wasn't he eating at the, wasn't there food? Wasn't he eating food at the time?
yes, and the
So, I
ER tech
mean-
also...
right,
So it could, oh, I'm sorry. Sorry about that. He could have, I mean, he was eating, so that could easily...
and he even said that he thought that the food didn't agree with him, and he also complained of abdominal pain and nausea.
The EMS tech testified that he was not compos mentis, not all there. He was never tested for food poisoning. He was admitted for being drunk. That's
Okay.
what the records say.
Thank you so much.
Thank you, Your Honor.
Cadigan versus Liberty Helicopters. You may proceed.
Good afternoon, Your Honors. Allison Sirkoof, Condon and Forsyth, on behalf of defendants, appellants, Nyon Air and Fly Nyon. May it please the Court. The central question for this Court to decide is whether plaintiffs had sufficient notice of the forum selection clause to which they are contractually bound, either by reference to it in the fourth affirmative defense or by its production, both of which occurred here.
That's not the only issue before this Court, is it? The other issue before this Court is, notwithstanding that release notice, is whether your client has waived the ability to assert this defense by continuing in litigation actively for over 3 years. And we have a mountain of case law that so holds. So why don't you deal with that issue first?
Yes, Your Honor. With respect, the cases that are cited by the plaintiffs regarding the issue of waiver are not applicable here.
Why?
The first subset being the arbitration cases, which do not support plaintiffs' argument because the policy underpinning those cases does not apply here. The policy being that an arbitration defense being...
But the policy that I'm talking about is that a litigant doesn't get to play in our courthouse, waste our judicial resources, and then say, I don't think I want to be here anymore. You don't get to do that. Once you engage in the game, you're in for the full ride.
I would point the Court to the Walker case, which discusses the fact that waiver occurs when a defendant fails to assert a bar to the action in its answer or by timely motion and elects instead to conduct discovery. The only two forum selection cases that plaintiffs cite that discuss waiver, the defendants did not assert forum selection as a defense.
But as
in
a
their
general
answer.
policy, you talk about arbitration cases, you talk about that there are no specific cases as to waiver or forum selection, fine. As a general policy, you and your adversary engage in extensive litigation and discovery over a period of 3 years. So why then would it not be prejudicial at this point in time to say, oops, sorry, there was no waiver of the forum selection clause and therefore you're out?
Plaintiffs put forward two bases for prejudice. The first being that the resources in New York have been wasted, and as discussed in the Madden case, that is not a basis for prejudice because it is of plaintiff's own making. When what we're talking about is enforcing a contractual...
No. You can waive any contractual obligation or anything in your contract. And so you assert in the most general way, which is really clearly the most general way, plus there's a form, because you signed this form, you're out. Not saying specifically about forum selection. Let's be real. You didn't say anything specifically about the forum selection. And then you litigate for 3 years. That is a classic, and I've seen hundreds of cases where someone who takes that position, and if you look at the PJI definition of waiver, what you did is exactly it. It doesn't matter what type of case it is, it matters what you did. You litigated for 3 years, you took depositions, you produced thousands of documents.
20,000 pages of documents in pretrial discovery, extensive discovery requests upon the plaintiffs, 14 party and expert depositions, discovery motions, on-site inspection of the helicopter.
It is the Nyon defendant's position that once the defense was asserted as an affirmative defense in its answer, it preserved the right to move upon it as it wished.
At any time, 5 years hence,
Nope.
10 years hence? I mean, how long could he wait? Could they wait without having a waiver and without wasting our court's time?
There is no bright line as to the outside mark, but we clearly have not reached it here.
Oh, you certainly have. You certainly have.
When the most operative amended answer was filed in January of 2020, and then we moved in June of 2021.
So for that 18-month period, first of all, in that last answer, did you actually say the word forum selection clause?
There,
Nope.
in the
And
answer?
then 18, right.
No.
And 18 months more of litigation. And you're saying for some reason that you don't think that your actions absolutely evidence an intent not an intent to waive?
As discussed by
What
the
did you do during that entire 3-year period that would indicate that you didn't intend, other than say, we have a document? Other than that, what did you do?
Having asserted the defense in our
I'm saying,
answer,
I agree, we agree. You said you signed a release, right? Not that said nothing about the forum selection clause, even though it was in there, right? Other than just saying there is this document, what did you do to indicate your intent to rely on the forum selection clause for the 3 years that you litigated?
and then having produced the agreement in discovery, it is incumbent upon
I'm asking, but that's not what did you do in that 3-year period to indicate that you intended to rely on the forum selection clause?
having preserved the
So
defense
the answer
in
is
our
nothing,
answer.
right?
Nothing.
I think that's the answer.
Thank you. We'll hear you on rebuttal.
Thank you, Your Honors.
You may proceed.
Good afternoon, Your Honors. May it please the Court. Brian Isaac. I represent the plaintiff, respondent, cross-appellant. I'm going to truncate my argument. I do want to point something out. Judge Gesma, you asked a question as to when you would have to assert the defense. I think the defendant's answer is on page 18 of its main brief, and I'm quoting, not Brian Isaac. This is the defendant. Once a defense is properly raised in the answer, a defendant may rely upon that defense regardless of its litigation activity. The operative word being regardless. Under that scenario, they can litigate the case right up until trial. They made a 3211A1 motion, which isn't subject to Brill constraints, and they can move to dismiss. That's just not the rule. Now, to be fair, they said something completely opposite on page 19 of their brief. This is one page after, and I'm quoting again, not Brian Isaac, this is the defendant's. Litigation activity may constitute waiver of a forum selection clause when a defendant fails to assert a bar to the action in its answer or by timely motion, and instead continues to conduct discovery and to fully participate in the litigation, acts inconsistent with its later claim that litigation in the forum was not appropriate. This case, you can say a lot of things about the lawyers here, but they did some litigation, 14 depositions. I mean, I do labor law cases, product liability cases. You never see that. 20,500 pages of documents, 5 motions. I mean, this is just a classic waiver. And the problem that we have is it's even worse than that, because Judge Scarpulli, you asked about the clause. I just want to go into that for 30 seconds. I'm not going to take my 5 minutes, I promise, but I don't think they asserted a forum selection clause. They asserted a liability
they
waiver.
asserted a document. Look, they asserted this document, whatever it says, relieves us of liability. We're a notice pleading state, right? And I've seen, and both plaintiffs and defendants, I mean, was it the model of clarity? Totally agree with you. It doesn't say those words, but I agree with you, but I don't know that
I understand your point. Just give me 15 seconds, because I want to read it to you, because I think I have a syntactic or linguistic argument that you might actually like. This is, and they didn't say it once. Okay, it said it 3 times. Okay, I know an amended pleading, amended answer supersedes the original, but 3 times. Quote, recovery is barred or reduced by a pre-flight liability waiver executed by defendant, plaintiff decedent Trevor Noah Cadigan. Now, a forum selection clause is not substantive. We all know that. It's procedural. How could you possibly use the word reduced in that situation? And I just have one other point. I know you're shaking your head, but
look, you and I've seen 30 affirmative defenses and 30 claims that are basically just punch the button and spit them out. So I don't really...
Fair enough. Fair enough. The only last point I'll make, and I'll sit down, is how many times do I have defendants actually taking my position? right? I have lawyers going to get up, he's going to take my position. Two of the other defendants took my position. So to me, this was not an appropriate argument, and as you know from our brief, we believe it was frivolous, which is why we took a cross appeal. Thanks for listening to me.
Thank you. Okay.
Good afternoon.
Good afternoon.
This is David Lowe for Defendant Respondent Apical Industries. Based on how the oral argument is going, I don't have anything further to add. If you have any specific questions, I'm happy to answer them, but I'll stand pat for now. Thank you. Thank you.
Okay, thank you. You have 2 minutes.
Your Honors, under the Callaway holding, having asserted an affirmative defense in the answer, the objection is reserved for trial. The waiver cases that are cited by plaintiffs fall under the rubric of either arbitration or forum nonconveniens, neither which are applicable here to forum selection clauses. And there are several cases cited in our briefs.
So, Counsel, going back to the portion of your brief read by Mr. Isaac, is it your position that you could make this argument on the verge of trial, even if trial was delayed for 8 years or 10 years?
We were not on the verge of trial, so I don't need to make
understand
that
I'm
argument.
not asking you that. Given your phrasing in your brief of regardless of how long, is it your position that if it took 8 years to get to trial, you could still make the motion at that point?
I think there would have to be a showing of prejudice. And delay is not sufficient under the case law to have a showing of prejudice. Several years of litigation.
So you are basically disregarding all of the case law that says if you've engaged in protracted discovery and litigation before raising this affirmatively, okay, that it doesn't matter. That's what you're saying, but I have not seen not one case that says that.
I'm not disregarding them, I'm distinguishing them. The policy underpinning the arbitration cases.
Distinguish, I mean, there are so many, I can't, CDR credenza, there the court said, the claim defense for lack of personal jurisdiction, forum in France, waivers, etc., are not available after several years of litigation.
In CDR, there was no affirmative defense asserted preserving the forum selection clause defense.
No, they raised a bunch of stuff.
There was no...
Just like you, and it did not specifically say, just like here, did not specifically say, we have a forum selection clause.
It is specifically stated in the case that there was no affirmative defense asserted raising forum selection. Same with Jiangsu,
Yeah, but if,
Jintan,
counsel,
which is the other
if that's your argument, anyone can amend their answer at any time.
Yeah.
So if you're saying 15 years in, I can amend my answer and say, oops, now, and plus, this is not a statutory defense. This is only a defense that you are raising as a contractual matter. That, I think, is the policy behind it. If you get this defense only by contract, not by statute, not by the CPLR, not by anything else, you can waive it by not asserting it and requiring the other party to do 3 years of litigation. I think that is really what the policy that we're talking about here. You are not talking about a defense you get because of any statutory condition. Right?
May I answer? May I?
Briefly.
Yes.
Sure.
I think that is part of the point in the cases that discuss several years of litigation activity does not necessarily waive a forum selection clause defense because it is a contractual right. And the prejudice in that event is of the plaintiff's own making in not having filed in the agreed upon forum. That's distinct from the arbitration cases where a defendant may reap the benefits.
But it's of the plaintiff's own making because you don't have a right to say, I'm sorry, this is the wrong place, immediately, not 3 years in. Again, you wanted to talk about policy at the beginning. The policy here is don't waste New York State's judicial resources and then say, I don't like this forum anymore, I want to go somewhere else. If that is your right, assert it immediately. Thank you.
Thank you, Your Honors.
People versus Lopez.
Good afternoon, Your Honors.
Good afternoon.
Richard Hirschfeld for Appellant. I would like to focus on the ineffective assistance counsel point and specifically counsel's complete lack of familiarity with the operative law regarding conspiracies.
Counsel, was there 440 here?
I'm sorry?
Was there a 440 motion filed?
There wasn't, but I believe, Judge, that on this record.
Counsel, you want to climb a very tall mountain, but go ahead.
Okay. Well, if you take a look at some of the cases we cited in our brief, Gordian, Holland, and Yagudev, each of those concluded that a 440 was not necessary based upon counsel's clear lack of comprehension of the law applicable to the charges.
So how have you shown that counsel was unfamiliar with the law of conspiracy?
Well, a number of different ways. The most, and you could say that some of his comments were designed to appeal to jury sympathy or jury.
So how have you shown that counsel was unfamiliar with the law of conspiracy?
Well, I mean, if you take a look at his comments to the court, asking for a charge that said there was no presumption that could be drawn from large quantity purchases of narcotics, which was completely contrary to the law and permeated his arguments, his decision to have appellant testify, and
strategic. Why is that not strategy? And we don't know what the conversation was between he and his client in terms of the defendant testifying or not testifying.
Yeah, but Judge, if you when you look to the arguments made to the court, not in front of the jury, I believe this court and other courts have concluded that you can disregard or discount any attempt at jury nullification or jury sympathy or strategy.
You're not getting up that mountain because, again, we're talking about strategy. I do not understand what has been stated or what's in the record that would show that it was not strategy. Again, since we don't have a 440, so therefore we don't know what counsel was thinking.
Well,
I mean, in this case, the defendant was kind of dead in the water, right, in terms of the conspiracy. We had the wiretaps. We had all the other information that he was involved in some type of drug conspiracy. So, what was counsel supposed to do? He's arguing that, it wasn't that drug conspiracy, it was another drug conspiracy that he was involved in. What else could he really do?
Well, the problem with that is you end up with the defendant admitting to his violation of probation, which is an equally serious charge, without any real benefit.
Well, the violation of probation in light of the weight here was a cakewalk.
Right. This was a 54-count indictment, and he's charged with conspiracy in the 4th degree. Come on.
The problem, though, is that his lack of comprehension, which I think the record discloses, necessarily affects how he advises the defendant.
We don't know. Because we don't have a 440, we don't have an affidavit from counsel as to his thinking.
Okay, in that case, I'll rely on my brief. Thank you, Your Honors.
Thank you. You may proceed.
Good afternoon, Your Honors, and may it please the court. Julia Gorski for the people. I did just want to start by saying that defendant does not fairly represent the law of conspiracy as it was presented to the jury below. The presumptions that he raises on appeal are for this court to apply when they're reviewing a conspiracy conviction for legal sufficiency. I also did want to note that the very fact that the trial court saw fit to give the multiple conspiracy charge to the jury refutes defendant's claim on appeal that it was an untenable defense. The judge did not have to give that instruction to the jury, but he said that it was not an evidence-based argument. In response to defendant's claim that, he took the stand and he admitted to violating his probation, even if defendant didn't testify, it was in the wiretaps that he told Gonzalez repeatedly that he was meeting with his probation officer. So this court should reject defendant's ineffective assistance of counsel claim, not only because it's not properly raised on direct appeal, but because the existing record shows that he received meaningful representation and defendant has not and cannot show that he was prejudiced in any way. This court should also reject defendant's legal sufficiency and weight of the evidence claims. The legal sufficiency claim is not preserved for appellate review, and given the overwhelming evidence against defendant, the jury's verdict was in full accord with the weight of the evidence. And if there are no further questions, I rest on my brief.
Thank you. Counsel, you had 2 minutes.
I guess just one more comment on the lack of a 440. I believe if you look at the Holland, the Gordian, the Goodove case that we cite, I don't think any of those had a 440 involved, and each of those concluded that based on the arguments of counsel, which was clearly contrary to the prevailing law. For instance, one argument, and he had his client testify, was that you can't shoplift unless you leave the store, when the Court of Appeals had recently held that you can shoplift when you don't leave the store. So that is not a strategy decision. That's just a clear misapprehension of the law, and we would submit that's what you have here. Thank you.
JG Jewelry versus TJC Jewelry. You may proceed.
Thank you, Your Honor. May it please the court. This appeal boils down, I think, to one issue, which is whether pleadings matter. Whether parties are bound to their pleadings, which have the force of judicial admissions, or whether they can change them at their convenience as the litigation proceeds. And here the pleadings are quite unambiguous. Starting with the very first line of the amended complaint, the alleged joint venture and the corporate entity JGJ are defined interchangeably as the same entity. Then repeatedly in the amended complaint, we are told that JGJ was, quote, the corporate embodiment of the joint venture created for that role. It's also clear from the amended complaint that on April 2nd, 2015, JGJ was formed and the joint venture began formal operations.
So basically, counsel, your argument is that the joint venture did not exist because at the outset of the partnership, they decided to operate through a simultaneously formed corporation, right?
Right. My argument is based on this court's decision in Lombard and the Fourth Department's decision.
But in Lombard, Lombard involved a fact pattern where a corporation was established well before the so-called joint venture, unlike here, where the difference is whether that conduit corporation was really formed concomitant with the joint venture that year, where discussions were going on between February and April, and then the corporation, or as set forth by the affidavit by the principal of the plaintiff, that the corporation was established well after the joint venture for purposes of being a conduit between the plaintiff and the defendant, right?
The plaintiffs are bound by their allegations, and their allegation is that the joint venture came into existence at the same time, began operations at the same time as the corporation, and the corporation embodied the joint venture, and all operations, all financial arrangements, et cetera, were funneled through the joint venture. So they're making very clear
that's not their allegations, right? Didn't in opposition to your pre-answer motion to dismiss.
Over there.
Over here.
She's talking.
I'm sorry.
They submit an affidavit by which they are allowed to amplify their pleadings and say, no, that's not our allegation. Our allegation is that we formed this joint venture months before the corporate form was taken, and the corporate form was taken so that we could do it would be easy to account between us the money. That's what their affidavit said, right? And don't forget, we're on a pre-answer motion to dismiss. We're not on a summary judgment motion. Been no discovery. So taking those two things together, as you request we do, they are bound by all those allegations. Why do we dismiss the joint venture?
You're allowed, on a motion to dismiss, you are allowed to supplement and amplify the pleadings. What you're not allowed to do is to contradict the pleadings. The pleadings here are unambiguous.
Why is that? It's not a contradiction. They say that, yes, it was exactly. We formed this corporation as part of the joint venture, which is completely legitimate. So why is that, on a pre-answer motion to dismiss, a reason to dismiss the joint venture claim?
Because, again, the rule of Lombard and Bianchi is clear. The joint venture has to precede the corporate entity. Here, it did not precede the corporate entity. They were formed simultaneously, and the corporate entity
That isn't what the
joint
plaintiff
venture.
alleges,
Those are
is
not-
it, counsel?
Respectfully,
Is that?
Your Honor.
Counsel, when one of the judges is speaking, I need you to please be quiet and listen,
Yes, Your Honor.
okay?
Do you dispute that the plaintiff is alleging here, between the complaint and the opposition to the pre-answer motion to dismiss, that the joint venture preceded the corporate formation?
I am disputing that the affidavit supplements or
I'm
amplifies.
just asking that, but that's not my question. My question is, are you disputing that that's what the plaintiff alleges?
They are purporting to allege that, but they
Okay,
are
so then this is a pre-answer motion to dismiss. We all agree that that's what they allege. Maybe it's not true at the end of the day, and on summary judgment, you win. But who knows, right?
Well, my point is, if you allege that the light is green, you can't come back in an affidavit and say it was red.
Okay.
That is what they're doing.
All right, you'll have time on rebuttal.
Okay, thank you.
You may proceed.
May it please the court, Gregory Fleisler, Moses and Singer on behalf of respondents.
So, counsel, are you alleging in your complaint that the light is green and then submitting an affidavit in opposition to the pre-answer motion to dismiss, saying that the light is red?
Absolutely not, Your Honor.
Tell me why not.
Counsel, can you bring your mask over your nose, please?
Yes,
Thank you.
I apologize.
No problem.
Perhaps there was a bit of inartful pleading in the complaint. Originally, it was pleaded, as the complaint says, that the joint venture and the corporation were formed on the same day. As a result of further discovery and learning information, over 2 million documents have been exchanged. In this case, it has been rectified that the joint venture began at the beginning of 2015, several months before the corporation was formed. The parties were discussing it. They had memos between each other. Defendants themselves announced to customers and clients that a joint venture had been created
How
between the
soon?
parties.
No, so let me just ask you that. I saw that. What was the what date is the announcement, defendant's announcement, and when the corporation was formed?
So defendant's announcement occurred in February 2015, and the corporation was formed in April 2015.
So, okay. So, I mean, that is your position, and who knows, maybe you take that position only because you think there are documents that support you, and no one's going to say that on deposition or whatever, and it might be a motion for summary judgment, right? But your position is it was formed earlier.
Yes. Additionally, Your Honor, all the evidence so far, at least, shows that the corporation and the joint venture were completely distinct from one another. As Your Honor pointed out, the corporation was formed so the parties could account to each other within the much larger and broader joint venture. In the context of the joint venture, which occurred from early 2015 to late 2017, the corporation, in the context of this international jewelry business, never designed jewelry, which was designed and manufactured by the joint venture. They never manufactured jewelry, and they never made any sales to third parties. So this further...
What was the point of the corporation?
I'm sorry?
What was the point of the corporation?
The point of the corporation was so that the parties, defendants and plaintiffs, could account to one another in the course of the joint venture.
Account?
Account, yes. That is, the internal transactions went between the corporation, so the parties could account.
Who did the jewelry designing?
I'm sorry, who did the design?
Who did the jewelry designing?
Both parties did design. When I say both parties, not the corporation at all that we're talking about. Both plaintiffs and defendants did the design. Our parties did much of the design that they shared with defendants, in terms of knowledge,
And those,
artistry.
were those designs owned by the corporation or owned by the joint venture?
None of the designs are owned by the corporation, that's for sure.
Okay.
With respect to the joint venture or individual parties to the joint venture, I can't say. I think we'll have to wait for some discovery to determine that for certain.
Okay.
I don't know if there are any further questions. If there are no further questions, respondents are happy to rest on the briefs and the evidence submitted.
Thank you. Okay, counsel, you have a minute.
Okay. I will submit that this was not just a quote in artful pleading. Every document that was introduced in the affidavit, the plaintiffs had access to from the beginning. These are alleged draft agreements. These are emails, all of which they had access to.
Let me just ask you, do you dispute that that your client announced the joint venture 2 months before the corporation was formed?
I don't think we dispute the authenticity of that email, but that doesn't matter because they had access to that email. They could have pled it differently if they wanted to.
So can't they just amend their complaint now to conform the pleading to the proof?
Again, you cannot take a material fact, the light is green, and then say it's red. You're bound by your material facts. This is our company, my client is $1 billion company. They're alleging they agreed to essentially merge themselves with a far smaller entity based on an all agreement. At least we should have notice of what that all agreement was. And they can't just change what the all agreement was as the litigation progresses at their convenience. They are bound by their judicial admissions as contained in the allegations. You just don't shoot and ask questions later. If you're going to plead a complaint, you do the research and you put in accurate allegations because you know you're going to be bound to them throughout the litigation.
Thank you.
Thank you, Your Honors.
People v. Morgan McGee. You may proceed.
Good afternoon. Samuel Claflin of the Legal Aid Society on behalf of Morgan McGee. In the circumstances, Mr. McGee's sentence is a first offender to 6 months in jail and 5 years of probation.
He set the man on fire.
That's correct, Your Honor.
And as the man was on fire, he threw lighter fluid on the man. As the man is burning and is inflamed, he throws lighter fluid on the man. He receives 6 months incarceration and probation, 4.5 years probation. How is that excessive?
A factual point, Your Honor, I believe the record does not support that lighter fluid was sprayed onto the victim here after the fire had already been started. I believe the lighter fluid had already been sprayed at that time.
Oh, I apologize.
I don't think that helps him too much.
I apologize. You're right. I do apologize for that. It wasn't lighter fluid after he set the man on fire. Okay.
So I think it's crucial to acknowledge here that this was an isolated incident. This is Mr. McGee's first and only offense that arose in the context
And that's, counsel, I appreciate the position that you're in, but there's no way that in any stretch of the imagination, we can take this fact pattern, okay, and say that this plea was excessive. No way.
Well, so again, this is...
If it weren't for his first arrest status, if it weren't for his mental health issues, etc., he would be in jail. We all know that for this case.
Can I just mention one other thing? The man was asleep when he set him on fire. I know I keep harping on this setting on fire thing, but I mean, the victim, the complainant was asleep when he did this, right? So the defendant, again, was sentenced to 6 months incarceration and 4.5 years probation. And he's currently on currently on probation, right? So what is it that you're seeking?
We're seeing a reduction in the probation, Your Honor. The incarceratory sentence has already been served, of course. So acknowledging that this was an incident that arose in the context of a uniquely stressful situation in which Mr. McGee was residing at a homeless shelter at the time, this was an aberration, an isolated incident, given his then unaddressed mental health and substance abuse issues.
Right, and I saw in the record that the court went through extensive discussions with defense counsel in terms of Mr. McGee's mental health status, his physical status, et cetera. And this was one of the reasons why the 6-month split was agreed upon.
Our position is that the sentence was nonetheless excessive, Your Honor. Mr. McGee's trial counsel arranged for him to have community treatment opportunities to address the issues that he had, specifically substance abuse and mental health issues again. Further, here Mr. McGee's already been punished. He served over 1.5 years in jail and several years of probation. To the extent probation was beneficial for him, he's already received that benefit. Further probation would be counterproductive.
What are we talking about, 6 months?
The 5-year probation sentence, Your Honor, plus the 1.5 years of incarceration that Mr. McGee served.
Counsel, please. My question was real simple. What do we got left? 6 months, right?
Until May 2023, Your Honor.
Okay.
So given that, the extent that he's already served probation time and the incarceratory time, he's already received the benefit of his sentence. Community safety's already been ensured, given that this was an aberration, the incident. So as this court has done many times before, it should reduce Mr. McGee's community supervision time, acknowledging the ample social science research suggesting that excessive community supervision can actually do more harm
So
than
does
good.
the less is more legislation, does that change this in any way?
It does not, Your Honor. Less is more applies only to post-release supervision and parole, whereas Mr. McGee is on probation. So this court could, acknowledging the kind of rationale motivating the Less is More Act, could certainly, in the interest of justice, reduce Mr. McGee's sentence here, given that he is on probation. Further, I think it's very crucial here that Mr. McGee served over 1 year in jail for which he did not receive credit against his probation time. This is under a Court of Appeals precedent. However, in the interest of justice, this court can take account of that fact.
So the incident occurred in 2016. He pled guilty in 2018. So why did he serve over 1 year incarceration?
So he was in jail awaiting trial, Your Honor, or until the point of the plea, rather. So from the day
So
of
you're
arrest,
so when you talk about his serving over 1 year incarceration, you're talking about because of the pre-plea detention.
that's exactly right,
So
Your
at the
Honor.
time that he took the plea, he had
He went
already
out.
served his 6 months. He was released.
Right.
Is that correct?
No, Your Honor, he was in jail the entire time from...
No. Once he took the plea,
Once he took the
because he was sitting in jail for a year
Yes.
waiting for the plea, he walked out the door.
Apologies, yes, I misunderstood Your Honor's question. However, over 1 year of his jail time was
We
not
got it. You
counted.
can tell us on, on rebuttal, okay?
Thank you.
All right. You may proceed, counsel.
Good afternoon, Your Honors. Kalani Brown on behalf of the Bronx County District Attorney's Office.
So he pled guilty to assault in a second, right?
Yes, Your Honor.
What was the maximum?
The maximum was, for the assault, was 7 years and 3 years of post-release supervision.
And so he got a 6-month split.
Yes, Your Honor. Your Honor, the courts do not need to engage in any particular litany when it comes to the waiver of appeal, and so the courts look at the totality of the circumstances when coming to a decision. As in here, the defendant was not under the influence of any alcohol, drugs, or medication. The defendant was advised by counsel, did have on the record acknowledgement of the waiver, and the written waiver was a supplement to the court's oral colloquy or lack of the defendant's misunderstanding.
Counsel, do you agree that the sentence, that the probationary period of the sentence should end actually in December 2022 instead of May 2023, because it should have been concurrent with this sentence with the incarceratory portion of the sentence?
No, Your Honor. The 18 months that the defense is mentioning that was spent from the arrest date to the plea and sentencing was spent trying to find...
No, I understand that, but isn't it accurate that the maximum of the probation plus the incarceration should have been 5 years, whereas this was 5.5 years, given the way it was structured.
Yes, I'm not understanding the question. Sorry, Your Honor.
Okay.
So at the time of sentence, right, he had, because of the time he had already spent in jail, that portion, the 6 month, had already been completed on the date of that he took the plea, correct?
Yes, Your Honor.
Okay, so that, but he was sentenced to 5 years probation, correct?
Yes, Your Honor.
So typically, with a split, it's 6 months in, 4.5 on probation. Why did he not receive that credit?
I'm not sure as to why he was not given the credit.
And doesn't, by operation of law, isn't it supposed to be by operation of law concurrent?
I do not have that information right now, Your Honor.
The penal law does so require that. So it seems to me that this is, we're mandated by the law to make sure that this sentence is correct.
Yes, Your Honor, I understand.
Okay, all right. You have anything further?
Yes, Your Honor, I would like to mention that the judge, as well as the prosecution and the defense, spent a significant amount of time, the 18 months to be exact, trying to find housing for the defendant, also trying to find a resolution that would best
serve
suit all parties involved.
Yes.
And so we believe, based on the gravity of the offense and the leniency of the plea agreement, that the sentence, was fair and proper.
Thank you.
And so if the judge does not have any additional questions, the people will rest on our brief.
Thank you.
Thank you, Your Honor.
Counsel? And counsel, before you start, let me say to you that as I read this case, I was very happy to see both sides here work so hard with the court to try to get to a proper resolution for this particular defendant, notwithstanding the horror of his act and how bad this could have gone. So I say that to say I commend all of you for how this case evolved. You may proceed with your argument.
I appreciate that, Your Honor. Picking up with Your Honor's questions for my adversary about Mr. McGee's release date, it appears that the Department of Probation may have miscalculated his release date based on the 6 months and the 5 years that were to run concurrently. So to the extent this court is able to remedy that, certainly we are asking the court to do so here. But I would like to reiterate that there's a separate issue as to the uncounted jail time, where he served over 1.5 years between his arrest and the plea, where only 6 months of that time actually counts against the probation to get to the full.
Nothing else you can do. There's no alternative other than a 6-month split unless you get straight time. So, I mean, that was the only alternative, and he walked out. And I recognize that he was in the 18 months, but unless he got straight jail time, there was nothing else that you could do.
This court's interest of justice power is plenary in terms of reviewing excessive sentence cases, and so we would ask this court to acknowledge this anomaly where Mr. McGee spent the 18 months.
So what you're asking, therefore, is that we modify the sentence to time served, right?
That's what we're requesting at this time, Your Honor.
Thank you so much, and again, the thanks of the court for the exceptional work on this case.
Thank you, Your Honors.
Rose Group, Park Avenue, LLC versus Third Church Christ. You may proceed, counsel.
Good afternoon, Your Honors. David Wolf for the Appellant Third Church. There's quite a few discrete separate issues presented on our appeal, so I'd like to proceed through them in order, if I may. Number one, there's the issue of lost profits, which the tenant is seeking to recoup in its fourth cause of action. The lease does not permit the recovery of lost profits, and in the absence of a clause allowing such a recovery, they're not recoverable. That branch of their complaint should have been dismissed. Additionally, there's undisputed extrinsic evidence that Lost profits were never in the contemplation of the parties when they signed the lease. Article 23.1 of the lease does not in any way, shape, or form support the tenant's argument. It's exactly the same, or substantively the same as...
So, counsel, what do you do with the tenant's bad faith argument? You know, you kept the scaffolding up for 3 years in bad faith.
Well, there's no evidence of bad faith, but beyond that, this...
Well, I mean, just the fact of 3 years, and it's clear you didn't get right. You don't dispute that you didn't get the permission to put it up, right?
Well, the work's been ongoing. Like, they've done work.
That's not an answer to her question.
I'm not sure I understood it then.
You don't dispute that you were required under the lease to get permission to put up the scaffolding, and you didn't do that.
Permission from the tenant? No, we're not required to get permission from the tenant.
Isn't under the lease, don't you have the obligation to inform the tenant and get their approval of or some kind of consent?
No, we don't. What Your Honor, I believe, is referring to is Article 37.1 of the lease, which the tenant contends gives them a veto over any structural repair work. It doesn't actually say those words. There's nothing in there.
I read it, okay, but I'm saying, let's just assume you didn't get that approval, right? And the tenant says you kept up that scaffolding for 3 unnecessary years. So even if we agreed that there was an exclusion of consequential damages, and plaintiff has pointed to some evidence of bad faith, why would we dismiss that as a matter of law?
The implied covenant of good faith and fair dealing cannot alter the express terms of the lease and provide a remedy that isn't there. Here we have both the absence of a clause permitting the recovery of lost profits, and we also have an exculpatory clause in 5.
Why don't you read me that exculpatory clause, because I don't think it says what you think it says.
I don't have the text of it in front of me, Your Honor, but it says in...
It's pretty unclear in that clause, correct? It doesn't say that under no circumstances can I get consequential damages for tort or anything else, right? It doesn't say that.
It says no liability for interruption to business due to the necessity of performing repairs. There's no question that these repairs were necessary. It's undisputed that there were chunks of debris falling.
No, I think the plaintiff does dispute that 3 years of scaffolding was necessary. Isn't that the whole point?
It's what...
I mean, can we do that? All I'm saying to you is, why isn't this an issue of fact?
Well, it's undisputed that there were chunks of facade falling.
Yes, but it is disputed that it needed to take 3 years to repair. And that seems to me an absolute issue of fact. Just because you say, no, it needed to take 3 years doesn't mean that's so.
Well, again, I just respond again that the implied covenant cannot change what's actually in the lease.
That's well and fine, but issues of fact are issues of fact.
Well, if the absence of a clause expressly allowing it could be circumvented by pleading it in this way, then the holdings of both...
Wait a minute. I thought I read in the record that there was discussions between the sides, that one side said, don't worry, it'll be the scaffold will be down within 8 months. 3 years later, the scaffold is still there. That by itself creates an issue of fact. That by itself.
Well, if Your Honors don't have other questions on that one point, then I'd
okay.
Because we do have a number of issues.
Go ahead.
With respect to Gala, Gala is an affiliate. Gala, 2 companies that are owned by husband and wife. There's no dispute over...
Oh, I hope I would strongly suggest that you reconsider that statement. Because a husband and wife can't have 2 separate businesses and the wife hold her own business down. Is that what you're saying?
Your Honor, the tenant is as much an affiliate of Gala's as Gala's is an
Counsel,
affiliate.
don't avoid my question.
I'm not saying that in any way.
That's exactly what you're doing.
Absolutely not, Your Honor.
So you want this court to say, as a matter of law, that where a husband and a wife own companies that do business with each other, they're obviously companies that are
So,
commingled such that there's no difference between the two?
Your Honor, I think I've stepped on a hot button inadvertently. Let me rephrase it. Family
I
members.
think that would be good.
Close family members operating complementary businesses where they share office space, where they share, I see I'm out of time.
Go ahead.
I just finished this. Where they share office space, where they share employees, where Gala pays money to Mr. Rose, Mr. Rose speaks for Gala, Mr. Rose gives instructions to Gala's employees. Gala is managed 100% by the CFO who reports to Mr. Rose, and it's also managed by Mr. Halquist, who is the tenant's
And aren't there
former-
issues of fact as to all of those factors, as opposed to
No, those are
being a
all,
clear, I mean, I'm astonished that you're claiming that all of those things are undisputed.
Well, they
Seems to me
are all-
There's a great deal of dispute as to each of those factors,
they're,
except for the fact that they're married to each other, which, as my colleague pointed out, is not in itself dispositive.
well, they're close family members, and it is
But
undisputed.
family members don't have to necessarily be corporations owned by close family members are not ipso facto related
Right, and
corporations.
I'm simply suggesting that's one of the factors that the court should consider. And
Sure,
there's-
and that's a question as to which it's one of many factors, and therefore there are questions of fact.
Mr. Rose testified that he gives instructions to Halquist.
So, counsel, let me ask you, is there a definition of affiliate in the lease?
No.
There's a definition of affiliate in Black's Law Dictionary that
No,
we
I'm
rely
asking
on.
you about I mean, look.
Remember the lease that you say that we are controlled by? We cannot look outside the lease when we're talking about consequential damages, et cetera. In that lease, is there a definition of affiliated?
No, there isn't. Article 41 uses the term affiliate to refer to companies owned by members of the Rose family.
How do we know that?
Well, if it's both in the text of the lease itself, it refers to affiliate transfers, and an affiliate transfer doesn't need landlord approval if it's within the Rose family. Importantly, Mr. Rose testified that the Rose Group is a family-owned business. His wife is part of that family. Companies she owns that operate there are closely connected. And again, if I may step to what's in Black's Law Dictionary and what's in the Second Circuit Court of Appeals decision in the VKK Corp case, shareholdings alone aren't dispositive. Where there is a close connection, there's no dispute that there's a close connection. Where they are related to, that's from Black's Law Dictionary.
Counsel,
they
are you
affiliates.
claiming that that's the only possible, that the definition is in Black's Law Dictionary is the only possible definition? What I was struck by in this lease was the absence of definitions of important language that I would have expected any appropriate lease to have covered, like affiliate, like event. I mean, there are a whole lot of terms that were just not defined.
Okay, you'll have time on rebuttal to ponder that query of my colleague.
Thank you.
Good afternoon. May it please the court. Ed Salcedo for Seyfarth Shaw on behalf of the plaintiff respondent. The panel has clearly seized upon the fact that there are a lot of questions of fact in this case.
Well, let me just talk about the affiliate. Why is that not an affiliate? Why is there a question of fact? There's testimony, right? The owner of the corporation doesn't have anything to do with running it, correct?
Correct. What we have is testimony.
Why is that not an affiliate? What issue of fact have you raised?
The issues of fact here are whether Gala is not an affiliate, it is a vendor. It's a closely held vendor. It operates in spaces other than just spaces owned by the Rose Group.
Because it's a photography firm, correct?
I'm sorry?
It's a photography firm?
No,
Or what
no,
is
it's
it?
lighting, it's sound.
Audio
Right.
visual.
It's
Does it
audio
work
visual.
for other than this venue?
Gala does. Gala works at other locations.
Okay.
And they,
You're saying that in and of itself raises an issue of fact whether it's an affiliate.
of what, it raises, well, we think it's dispositive that it's not an affiliate, but we agree that there have been allegations made and there's testimony which could cast.
Because there are certain venues that have in-house audiovisual departments that do all of the audiovisual exclusively for a particular venue.
Exactly,
correct?
exactly.
And what you've just said is that this gala company does audiovisual both for her husband's entity as well as other venues.
And she testified to that effect at her deposition. That was put in. There was testimony by Ms. Wilson, by Louise Wilson, who was the CFO, who works for both companies. She handles the books. Mr. Halquist, who only works for Gala, testified that he is at other locations. Gala does not share space with Rose Group. They have their own offices in another building where Rose Group has no offices of their own. To the extent that we keep hearing that Mr. Rose gives directions, he testified that insofar as when there is an event at the space, in the premises, and a client has made specific requests, Mr. Rose or members of his staff have communicated those requests to Mr. Halquist. For this event, this is what the client wants. This is what we need. That's what's going to happen at this particular event. The fact that Mr. Rose's wife runs this business, it's a completely separate business. She has no interest in Rose Group. Rose Group has no interest in Gala.
I think your adversary argued in their papers that the problem was that the wife had actually no experience in audiovisual.
That's why she hired.
That she delegated all the duties to a managerial staff or to others.
Which happens all the time.
Yeah. Is there something wrong with owning a business that you don't physically do but hire other people to do?
If there was, Your Honor, then there'd be a lot of places that'd be out of business. Here it was the idea of Ms. Lynn saw an opening, she saw a space that could be utilized, she went and hired people that did know what they were doing. This is all her testimony.
So in terms of the affiliation or the alleged affiliation, again, we have an issue of fact is exactly what the affiliation is or the relationship is.
Not only that, we have a question of fact as to what the lease means by what is an affiliate. So even if all this other stuff was not in question, even if we had no question as to who owned the business and everybody's in agreement of all that, we still don't know what the lease means. Now, the inartfully way that certain portions of this lease were drafted also leads to tons of questions of fact. With respect to the repair to the roof, if I could speak to that very, very briefly, Article 10 is what the landlord is arguing they did the repairs under. The problem is that Article 10 was only triggered when there's a material breach. Here, there's a question of fact, at a bare minimum, if there was a material breach, because of the manner in which the work was to take place. There was an entire colloquy between both sides when the work was to begin because of the extreme expenditures that Rose Group had to make with unforeseen issues with building out the space. There was litigation with the State Liquor Board. There was a bunch of money that had to get spent at the very beginning of this relationship, and the landlord, Third Church, understood that. And there's plenty, in the record, there's testimony, and there's documentary evidence that both sides agreed, all right, you spent a bunch of money on this, we can put this piece on hold. Then there's further testimony that when Rose Group finally said, okay, we're ready to start doing this, but we got to take out a loan, church didn't want to take out a loan. So then it decided to do it itself without any notice. So for Article 10 to apply, you have to have the material breach, and there's a question of material fact as to whether or not that breach occurred. So now we have more questions of fact. Then when we move on to as far as how long the work was to take, we have competing testimony between the experts on both sides, but we also have agreement. The engineer for Third Church agreed that a different method for protection could be used, netting as opposed to scaffolding. So there's a question of fact as to whether or not keeping the scaffolding up for that long was appropriate. And insofar as we're dealing with the consequential damages, controlling case law, which we cite, which I haven't heard any response to, Kalisic, Jarko Inc. versus the City of New York, the Court of Appeals specifically found an exculpatory clause is unenforceable when the misconduct for which it would grant immunity smacks of intentional wrongdoing, including bad faith. Here we have at least a question of fact, I would say, if not a little bit more, that there was bad faith on the part of how this work was being done to the exterior of the building. So insofar as Rose Group can prove its damages and can also prove that those damages relate to the scaffolding being up, there's a question of fact as to whether or not the exculpatory clause can trigger, one. Two, that brings us back to Article 10, because if landlord breached by keeping it up and wasn't supposed to do it, then the exculpatory clause can't apply to that. I see that I'm out of time. If the panel does not have any further questions that I can answer, I rest on our briefs, and we think that the decision should be affirmed.
Thank you. Counsel, you have 2 minutes.
Thank you. To Justice Gesmer's question about the absence of the definition, typically, and there's many cases, decisions by this court holding that when there isn't a definition, it doesn't create an ambiguity, and that the courts can and do look to Black's Law Dictionary. And I note that that's the same source of authority that the tenant cites to also for a definition. With respect to Gala, they are in fact an in-house provider. They are the exclusive in-house provider. Their equipment is built into the building. They are the only people who can and do operate it.
I know, but that's not all they do, is my point, that they have, because it's not a business that was built just for this venue, right?
It was built for it. It's branched out since then, but it is nevertheless an affiliate, given the close relationship and connection between the two of them. Also, just to work it through, and the tenant could conceivably form an entity in his son's name, in his uncle's name or whatnot, and just funnel 100% of the revenue to that affiliated entity to avoid paying percentage rent, and that's what they've done here. Gala is an affiliate based on the way it's used in the lease. There was a question to Tenants Council about delegation. The fact that the owner is a entirely hands-off owner and that she delegates all the responsibility isn't in and of itself dispositive, but she delegates 100% of the authority to the tenant's own CFO. An affiliate is an affiliate if there's an overlap in control.
So that sounds literally like an argument to a jury after trial. No one is saying that you can't argue that. And in fact, you are arguing that. You have every right to. The question is whether we take away the ability of the tenant to show its version of the same facts and say, under my version, there's no affiliation. And of course, your purpose is because you want more money, and theirs is because they don't. And even though the facts might be the same, without a specific definition of affiliate, which is almost universally put into an agreement, and shocking that it's not here, it's very difficult to make an issue of ruling as a matter of law, right?
May I
I'll let you
briefly
respond.
to that?
Yes.
Thank you, Your Honor. The absence of a definition doesn't make it ambiguous. And to the extent that the court perceives any ambiguity, it can be filled in one of two ways. Article 41 specifically refers to affiliate transfers as transfers within the Rose family. The owner of Gala is a member of the Rose family. That makes the company an affiliate. Secondly, where there's an ambiguity, even on a
So are you saying if they used an audio-visual company that was not owned, run by a family member, your company would not be entitled to a cent of their revenue?
If it's an arm's length, unaffiliated, non-family member, we wouldn't get a penny of that. They're permitted to have unaffiliated companies performing services, but when they have an affiliate, and an affiliate is used in the lease to mean Rose family, and it's a family-owned business, where they do that, it has to be included because anything else would permit them to do an end run around the requirements, and it's specifically in there. And I brought up that there are two things that the court could look to cure the ambiguity.
You're beyond the 2 minutes. I'm going to give you another 30 seconds to finish.
Mr. Saver testified as to what the term affiliate was intended to mean. He drafted the lease. He gave detailed and specific testimony that's based on personal knowledge, and it was undisputed. He testified that the word affiliate was meant to refer to members of the Rose family, companies owned by members of the Rose family. And it was undisputed. The tenant had an opportunity, to Justice Scarpulla's point about depriving them of an opportunity, they had an opportunity to put in an affirmation from the attorney who represented them, or from an affidavit from their own principals to dispute that. They didn't. So if there is an ambiguity, and I don't believe there is, it was cleared up, A, by Article 41, and B, by Mr. Saver's undisputed testimony.
Okay, thank you.
Based on personal knowledge. Thank you.
Thank you so much. Last but not least, Marcus Katz versus Max Marcus Katz and Sterling National.
Good afternoon, Your Honors.
Good afternoon.
May it please this worthy court, my name is Max Marcus Katz. I represent the appellant, and I am also here pro se. It is our contention that the court made a number of errors in awarding, first by awarding partial summary judgment to the respondent bank. Then the court committed error by not permitting the escrow account, which is the subject matter of this entire litigation, to be released. That has resulted in that account being held in limbo. Nobody has access to it. Nobody's using it. And finally, the third error we feel the court made was in not awarding any rights to the plaintiff's appellant to conduct depositions. There was not a shred of evidence submitted by the respondent bank in this case. The result is, as we sit here today, we stand here today, that we don't know anything about what transpired with respect to that employee that gave advice that the check was good, that the funds were clear.
And are you claiming that you were entitled to rely on an oral statement by the bank employee?
I beg pardon?
Is it your claim that you were entitled to rely on that oral statement?
A lie?
To rely.
Oh, to rely? When someone goes to the bank and the bank is supposed to service them, who else do you have to rely on?
Documents. Wouldn't it be wiser to have relied on checking documents to make sure that the deposit had cleared rather than to rely on an oral statement by an employee?
There is no way that I know of that one can check unless nowadays, and it wasn't so in this particular instance.
Mr. Katz, when you received that check and you made inquiries, and in fact, your own instincts on this record, you smelled something off about it.
Yes.
So as an attorney getting something like that, and you were representing the plaintiff, and this was the check that arguably was going to resolve an outstanding dispute, the $95,000, why couldn't you have checked back with the Citibank that issued that check and determined the validity of it? Why couldn't you do it from your end as opposed to going to the bank, telling the teller, I don't know, I have a good feel about it, and relying on oral statements? In fact, the agreement makes it clear that you should be bearing the risk because the bank does not have a fiduciary duty to you. It's a debtor-creditor situation. So I'm trying to understand, and this is trying to understand how you think you could, it's the bank's fault and I should have done nothing.
Not so. First of all, there's a question, am I dreaming about the fact that this check doesn't look right, number one? Number two, if you've ever gotten on the phone and tried to find out whether a check is good or not, you might as well give up practicing law.
But that's, to me, I mean, I think this is a most unfortunate situation, okay? And it's disturbing to me that you are bearing the brunt of this problem, okay? But our case law is very clear, and Greenberg really sets forth what the obligations are of the bank, what is not the obligation of the bank, and that case very succinctly and clearly says that it is the depositor who has the greatest ability to thwart off this kind of issue. And indeed, sadly, as my colleague said, you had an instinct about that. I just wish you had been a little more patient and waited to make sure that the money was in the bank, so that you would be okay. But based on Greenberg, I don't see how there is anything that we can do, notwithstanding our empathy for your plight.
Let me help you.
Okay.
It wasn't one instance, only.
Okay.
There were 2 instances.
All right.
And the second instance wasn't a situation where I went into the bank and said, Mr. Christian Fernandez, please send a wire for me. I didn't say that. It wasn't said that way. What was said was, can you check it out and find out if those funds were clear? Bite at the apple twice.
No, but the UCC says what it says, right? The banking system relies on the UCC. And the fact, yes, it was very unfortunate that someone took advantage of you, absolutely. And very unfortunate that someone at the bank thought to be a nice person, whatever, gave you false information. But it doesn't change the way the banking system works.
I understand.
And the banking system says you can't rely on it until it clears through the depository bank, which it didn't here. And therefore, when it didn't, you got charged back. That's the way the UCC works. That's the way the banking system works. And even if you went in and talked to the guy, you're not entitled to rely on it in obviation of the UCC, right? It is terrible that someone cheated you out of that money. No doubt about it. Yeah. And that person should pay.
Except for one thing. Let's go on to the next thing. One thing. How do we know today, as we stand here and as you sit there, and you've had the record and you have everything that to look at, how do we know that Mr. Fernandez was not part of the scheme?
And you should sue him. That's the whole point. If you think he's part of the scheme, then you should sue him.
He was an employee of the bank.
All right, you'll have time on rebuttal, okay? You may proceed.
Good afternoon. May it please the court. I'm Sumit Patel from Cullen and Dykeman, attorneys for respondent appellant Sterling National Bank, or Sterling. It's long been held that the UCC does govern this dispute, and there are reasons for that, and I think the court appreciates those reasons. Just very briefly, they include the need for certainty in the marketplace and efficiency in dispute resolution.
So on your cross appeal, you are seeking to hold Mr. Katz personally liable for his businesses?
That's correct, Your Honor.
On what possible basis could you even think of doing it?
Well, first of all, Mr. Katz has admitted having complete control of the corporation, of the Katz firm.
That's usually what happens when you have an LLC, a single-person LLC. It's not like there's a ghost who's doing everything, right? And that's, in fact, specifically why the law permits someone to incorporate themselves as a PC, because he doesn't want you to go after his car and his house for what his business does. So what is it that you think he has done that would possibly lead to either a piercing claim or individual liability?
Absolutely, Your Honor. And we're not suggesting that all single shareholder corporations are automatically liable.
I'm asking you specifically, what facts have you alleged?
We've shown there have been a number of lack of corporate formalities.
Okay, that we all agree. It has to be some kind of fraudulent action, right? Wrongful action. What have you alleged?
So we don't maintain, we disagree with the fact that it's got to be fraudulent.
Well, that's what the law says.
I think that there is.
Let's assume that we think that's what the case law says. What have you alleged?
Well, I mean, first of all, this court has recognized in the past that veil piercing is available.
I'm just asking you, what have you alleged? Give me what you've alleged in your pleading that would give rise to corporate, that would support fraudulent bad action.
Well, fraud in the sense that, Mr. Katz was the key central figure here, and he was...
Counsel, I mean, come on. He came in and told the bank, I'm not sure about this check. Can you check for me? That is like the antithesis of fraud and misconduct.
And you're not stating that did not occur, right? You're not denying that he did, in fact, present that to Mr. Hernandez, and Mr. Hernandez did it, or a bank employee, and the bank employee said, yes, the check looks good, right?
Well, we've operated on the assumption that even if what Mr. Katz is saying is true, even then the Katz firm is indeed liable. We would certainly reserve the right to dispute that.
But we're talking about fraud. Again, we're looking for instances of fraud and how you have put forth, or what your argument is as to what the fraud perpetrated by Mr. Katz would be.
Yeah, we have not alleged fraud in that traditional sense. Okay, well, I will certainly concede that. But we do maintain that the case law provides that in these circumstances.
What
the bank-
circumstances?
A circumstance where the bank has sustained an overdraft, that the account is in the negative now.
That automatically means fraud?
Does not, but we maintain, given the lack of corporate formalities, the fact that he was the key central figure in this situation, that the overall circumstances here, there's evidence that the firm is actually undercapitalized.
Wait a minute. What does that have to do with the price of eggs? So what?
We may not, the bank may not be able to recover against the Katz firm under these circumstances. And that is a
And so that equals misconduct?
It doesn't equal misconduct in the sense that, ultimately, it does mean that the bank does still get a judgment against the Katz firm. The concern here is that once we have that judgment, if Mr. Katz was the key central figure.
But that is true in every single solo LLC, and that is the whole point, right? And you know what? That's why the bank has insurance.
I was going to say, the FDIC, you're insured, right? $100,000?
We don't know if he has insurance or not at this point. But all we maintain is that it was too early in the procedural posture of the case for the court.
You have to plead something. You have to plead something other than I might not get paid to pierce the corporate veil, and something more than in a single person LLC or PC that there's a lack of formal corporate formalities. You have to plead something more than that. And I asked you 3 times, what more have you pled? And what you said is, we may not get paid. And other than that, you haven't said anything. So if you got something, now's the time to say it.
All right, we rest on our briefs and on the papers.
Thank you.
Thank you.
Okay, you have a minute?
I fully understand the concept of the case law, the UCC, almost being strict liability against the appellant. But one aspect that should have been followed by the bank, Mr. Fernandez, is, sorry, I can't pass judgment on this check. Maybe
I don't disagree with you, sir, that the bank should train its own people to keep their mouths shut until the bank has the money in the bank. Because this would not happen if employees followed their own protocol, okay? So I don't disagree with you, sir, on that issue.
I rest.
Thank you.
I get some order. Thank you.